We are going to explore an important international treaty in the field of intellectual property law that often receives less attention than the Paris Convention or the TRIPS Agreement. The Madrid Agreement for the Repression of False or Deceptive Indications of Source on Goods 1891. Although it is 130 years old, this treaty continues to represent an important milestone in international trade law because it addresses a simple yet significant problem. What happens when businesses falsely claim that their products originate from a famous place simply to increase sales? Let us understand why this treaty was introduced and why it still matters today. During the late 19th century, international trade was expanding rapidly. Consumers had begun associating certain countries and regions with superior quality products. For example, Swiss watches became synonymous with precision. French perfumes gained a reputation for luxury. Italian leather products became known for their craftsmanship. Japanese electronics were increasingly associated with innovation. As these products became globally recognized, dishonest traders started taking advantage of their reputation by falsely labeling their own goods as originating from these famous places. Imagine purchasing a bottle labeled made in Switzerland only to discover that it was manufactured somewhere else. Such deceptive practices not only misled consumers but also damaged the reputation of genuine manufacturers. To tackle this growing international problem, countries came together and adopted the Madrid Agreement for the repression of false or deceptive indications of sources on good on 14th April 1891. The primary objective of this agreement is straightforward: to prevent goods bearing false or deceptive indicators regarding their place of origin from entering international trade. The treaty seeks to achieve three important goals: protect consumers from being misled, protect honest manufacturers against unfair competition, promote integrity and confidence in international commerce. In simple words, if a product falsely claims to originate from a particular country or region, the importing country should have legal mechanism to stop those goods from being sold. Before moving further, let us understand a very important concept. An indication of source simply refers to any statement or label indicating where a product originates. Examples: made in India, product of Germany, manufactured in Japan, Swiss made. These labels influence purchasing decisions because consumers often associate particular countries with quality, reliability, or authenticity. However, it is important not to confuse an indication of source with geographical indication. A geographical indication goes a step further. A GI not only identifies where a product comes from, but also establishes that its unique qualities or reputation are directly linked to that geographical location. For example, Darjeeling tea, Banarasi sari, champagne. The Madrid Agreement primarily focuses on preventing false claims regarding geographical origin, whereas modern GI laws provide much stronger protection to products whose reputation is linked to a specific region. One of the most important provisions of the agreement is that member countries must take action against goods carrying false indications of origin. Such action may include seizure of imported goods, preventing their sale, confiscation where domestic laws permit, legal remedies against deceptive traders. The agreement also recognizes that misleading claims may appear not only on the product itself but also on packaging, labels, advertisements, commercial invoices, catalogs, promotional material. Therefore, authorities can examine the overall presentation of goods rather than merely the physical product. An interesting fact is that the Madrid Agreement is considered a special agreement under the Paris Convention for the protection of industrial property. The Paris Convention laid down general principles for protecting industrial property internationally. The Madrid Agreement expanded those principles by specifically addressing false indications regarding the geographical source of goods. Together, these treaties contributed significantly to the evolution of international intellectual property law. Today, international trade has become far more complex than it was in 1891. Consumers purchase products from across the globe through e commerce platforms, making accurate information about product origin even more important. Although newer treaties like the TRIPS Agreement and the Lisbon Agreement on appellations of origin provide more comprehensive protection, the Madrid Agreement remains historically significant because it introduced the idea of that false claims regarding the origin of goods should be internationally regulated. Its underlying principles continue to influence modern laws governing unfair competition, consumer protection, and geographical indication. India protects consumers and producers against misleading indications of source through several legislation. The Geographical Indication of Goods Act 1999 safeguards registered geographical indications against misuse. The Trademarks Act. Additionally, the Consumer Protection Act empowers authorities to act against misleading advertisements and unfair trade practices. These laws collectively reflect the same objective that inspired the Madrid Agreement more than a century ago. To conclude, the Madrid Agreement for the repression of false or deceptive indications of source on goods may not be the most famous international treaty, but it represents one of the earliest global efforts to ensure honesty in international trade. By discouraging false claims regarding the geographical origin of the products, the agreement protects consumers, preserves reputation of genuine producers, and promotes fair competition across international markets. Understanding this treaty also helps us appreciate how international IPR has evolved over time, from protecting the place of origin of goods to today's comprehensive framework governing trademarks, GI, patents, copyright, and other forms of intellectual property. Thank you so much for watching. If you found this explanation helpful, explore our other educational videos on intellectual property law and related treaties to deepen your understanding on this fascinating area of law.